Okay, continuing here on civil liberties, we're on slide number 37. Okay, we're talking about symbolic speech, okay? In other words, this is speech that is not obviously overt speech, but different actions that are symbols of things, okay? It tends to not enjoy as much protection constitutionally from the courts as actual, verbal speech. Okay, so in the case of, in 1968, the court upheld a conviction of a Vietnam War protester that burned his draft card. Burning a draft card is obviously symbolic speech. They argued that federal law prohibiting destruction of draft cards is intended to protect the military's manpower needs and not to prevent people from criticizing government policy. Texas versus Johnson, burning a flag, okay? The court upheld this, in fact, allows the burning of a flag, and it says the court protected the burning of an American flag in protest. Was this a controversial case? Yes, it was. If there's a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Okay, so it upheld that. Okay, obviously this is very controversial. Okay, so some of this stuff. Probably one of the more controversial cases in this chapter for sure is the case of RAV versus City of St. Paul. This was in 1992. This is a case where several teenagers allegedly burned a crudely fashioned cross on an African American family's lawn. The police charged one of the teens under a local bias-motivated criminal ordinance which prohibits the display of a symbol which arouses anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender. So the guy that did this, or the kids that did this, ran afoul of this, okay? And so the question before the Supreme Court was, is the ordinance that prohibits the burning of a cross on these individuals' lawns, okay, is that overly broad and impermissibly content-based? Is it a violation of the First Amendment free speech clause? Again, this is controversial. In a 9-0 vote, the justices held that the ordinance was invalid on its face because it prohibited otherwise permitted speech solely on the basis of the subjects of the speech that the speech addresses. The First Amendment prevents government from punishing speech and expressive conduct because it disapproves of the ideas expressed, okay? So this was a case where the court, again, said that it was okay to burn the cross because the law was written in such a way that was very inconsistent. Okay, this is where you have to understand when you start looking at constitutional law decisions by the Supreme Court. It's not just as simple as the cut and dried case, but there's also some backstory things within it. So in this case, it says, under the ordinance, we could hold up a sign declaring all anti-Semites as idiots, but not that all Jews are idiots. In other words, it was inconsistently written, and many times laws are struck down that way. So the court has been more permissive of symbolic speech, okay? And we just have to recognize that, okay? Other cases, again, as I'm talking about these are so controversial, and there's so much against these cases, but we got to talk about them, okay? If you go to the next slide there, slide number 40, freedom of assembly, okay? National Socialist Party versus Skokie. The court held that the right of free expression takes precedence over the mere possibility that the exercise of that right might have undesirable consequences. Okay, so what does that mean? Okay, the National Socialist Party, what's another name for them? The Nazis. Okay, so the Nazis are basically having a parade in Skokie, Illinois, where a large portion of Jews who survived the Holocaust reside. Is that an incredibly bad taste? Absolutely, positively, right? But the court said that Nazis may, again, they're protecting symbolic speech. Okay, controversial, yes. Okay, do I have big problems with that? Yeah, I do. Okay, another case. Okay, Forsyth County versus the Nationalist Movement in 1992. The court allows public officials to regulate time, place, and conditions of public assembly, provided that the regulations are reasonable and applied fairly to all groups, whatever their issue. So this idea of if you want to gather, to assemble, to protest something, okay, it's got to be done at a certain place, at a certain time, okay, so that it does not disrupt society generally, okay? You know, I'm going to have a rally at 3 in the morning, okay, and we're going to have it at about 183 decibels, okay? Yeah, it's not going to be constitutional, okay, because of that court case. In other words, freedom of assembly is not absolute. It's got to conform to, a certain place, conditions, and things like that, in order for it to be upheld as constitutional. Okay. Moving along here, slide number 41. Let's talk about freedom of the press and prior restraint. Okay. The idea of prior restraint is the ability of government to prevent something to be printed, something to be broadcast, something to be written. Okay. The government must allow it to be published, broadcast, whatever, okay? Can it be prohibited afterwards because of something you said? Perhaps. But one of the freedoms in our system of government is government cannot muzzle you, right? It cannot muzzle you and keep you from speaking or keep you from printing something, and in particular the press, okay? So there was a case called in New York Times versus United States, okay? This was, the New York Times basically got a hold of and published the Pentagon Papers. What were the Pentagon Papers? It was our troop movements in Vietnam. Okay, is that a problem? Is that a national security issue? What do you think? Basically publishing the U.S. troop movements over in Vietnam, right? If our enemies got a hold of that, could that be a problem? Yeah. Could American soldiers die? Yeah. But, the United States government tried to prevent those from being published. The court allowed it to be published because they said there is no prior restraint in our system of government, so that can be published, okay? Yeah, was that controversial? You bet it was, okay? Moving on here, okay? This is slide number 42, libel and slander, okay? Libel is something printed against you, okay, that kind of harms your character. Slander is something spoken against you that harms you. Okay, so basically, slander and libel laws in the United States are based on the assumption that society has an interest in encouraging citizens and news organizations to express themselves freely. Okay, so what that means is if you're a public official, you're a governmental official, a president, a legislature, a mayor, a councilman, whatever, and stuff is printed about you that is libelous, you are going to have a real hard time to sue, even if it's false, because the way the courts have ruled and the way they view a free society is, the idea is this: let truth get out there. Let the lies get out there. Let the truth beat out the lies. In a free society, when people are electing representatives, okay, and this is especially true in a campaign season, as I record this in 2020, is there a lot of slanderous things and libelous things being said and printed by both, against the candidates running for office? Yes. But the thinking of the courts is, in a free society, let it play. Let it get out there, okay? The assumption is the American people are smart enough to smell a rat. The American people are smart enough to pick out, to ferret out fake news, and that they will know what's true and what's false, okay? So the court, so they will protect writers, they'll protect, newspapers, this explains, the National Enquirer, if you've ever been in a checkout aisle in a grocery store, right? The Star, right? Boy trapped in refrigerator, eats own foot. Okay, these, you're like, how could you print this stuff? And then there's all kinds of scandalous things about presidents and senators and blah, blah, okay? They cannot be sued by public officials. They're protected, okay? Courts are less protective of a writer or a speaker when allegations are made about a private citizen like you or I, okay? If we're not a public official. Why? Because what is said about private individuals is considered less basic to a democratic process. In other words, nobody cares. Versus what is said about public officials, everybody cares. Okay, so when you hear maybe President Trump threatening to sue the press for something, okay, he's not going to win in court. The courts are going to protect the press because of this, okay? I'm going to end right there.